This is not a stage where the government is to be formed. This is a stage when an elected government is running. So your lordships for the first time will have to decide what are the discretionary powers of the governor in that context. And can his discretion be used to topple a government with respect to a set of people who say they are split from the Shivsena, when a Shivsena chief minister is already in place and the governor does not ask the Shivsena leader as to whether you are endorsing this or not? By not asking the Shivsena, he is recognizing a split. No, there is no discretion after an elected government is formed. The government then will fall, Mullah, on the floor of the House. Then the question of the discretion of the governor will come in. If there's a no confidence motion, government falls, then the question will come in as to who the governor will call. But the governor cannot by his act topple a government. No, the question is not that. When Malaj, the governor was approached, when the governor was approached by BJP as well as Eknath Shinde, and governor told us to have a trust vote, Malaj. On what basis did he ask us to do that? He obviously recognized the 39, otherwise he wouldn't have asked us for a trust vote. There was no occasion to. Because they continue to be in the Shivsena. That's their own case. That they did not, Malaj, move away from the Shivsena. So if they did not move away from the Shivsena, which is their own case, on what basis does the governor say you have a trust vote? Unless he recognizes that the 39 members are rebels, they have split from the Shivsena, therefore they and BJP have a majority, therefore you go and show your majority in the House and have a trust vote. That is, well, it's logical. That's the only way to look at it. And the governor must act consistent with constitutional morality. What's the moral foundation of such an act? I've already said deletion of paragraph 3. I don't have to read. Of course, it's a principle of constitutional morality. Well, then I want to just note the page, Malaj, in Nabam Rebia at page 1145. 1144. Paragraph 210, Malaj. Just note that. Para 210. Don't mistake the book, but just note that. I'll just read it. Last 4 lines, Malad, of that paragraph. Admittedly, the governor never called for a floor test, nor did he ever require the chief minister to establish his majority in the House. The governor's actions based on feuds and wrangles of a breakaway group, which is not recognized under the 10th schedule, cannot be constitutionally condescended.
What was the last sentence? The governor's? The last.
I'll just read it again. Admittedly, the governor never called for a floor test, nor did he ever require the chief minister to establish his majority in the House. The governor's actions based on feuds and wrangles of a breakaway group, which is not recognized under the 10th schedule, cannot be constitutionally condescended. It's directly on point. Because the governor, by asking me to go for a floor test, having a trust vote, has condescended to recognize a breakaway group, expressly prohibited and the governor's action struck down in Navam Rebia. So we don't have to go into the issue whether the matter should be sent back to the speaker or not. If you decide this issue, the matter is, nothing else is required to be decided. So we challenge the trust vote. We challenge the action of the governor to swear him in as chief minister. If that goes, everything else goes. Then we don't have to go into the problematic issue of sending disqualifications back to the speaker. And ultimately, Malaj, the facts are so crystal clear that they can't be the subject of yet another interpretation. They can't be, Malaj. The Constitution doesn't give him that power. The 10th schedule, he is far away, far removed from him. Para 3 has been deleted. Breakaway groups can't be recognized by that way, Malaj, every day a breakaway group will be recognized by the governor and governments will fall. I don't think, Malaj, the Republic expected this. And our Constitution, Malaj, ever envisaged a situation that can happen in our constitutional democracy. The whole integrity of the political process comes to naught.
Rameshwar says.
Nabam says the 3 areas in which the governor has discretion, beyond that, none. 371, Article 200, and Muller's forming a government at the initial stage after an election. There is no discretion with the governor. He acts otherwise on the aid and advice of the Council of Ministers. That's settled law. And of course, 356, Mullahs, sending a report to the central government. That's not something on the aid and advice because, so 356, 200 and 371. These are the 3 areas.
Mr. Zibal, once a person incurs a disqualification under the 10th schedule, then the consequence under Article 193, bracket 3, is that his seat shall thereupon become vacant.
Yes.
Because 190 in terms, 193 in terms refers to 191(2).
Yes.
Which refers to the 10th schedule.
That's correct.
So the seat shall thereupon become vacant. So suppose a group of MLAs, forget this case, suppose a group of MLAs incurs a disqualification by being a split, which otherwise is not recognized by the 10th schedule.
Correct.
So the strength of the House therefore falls by the extent of the disqualification.
Absolutely.
In which case the majority required for a motion of confidence would also be altered. So suppose in a House of 200 members, 20 have become disqualified.
Right.
Then it would be 90 instead of 100 for the vote of confidence.
Correct.
So would the governor in such a case be justified in saying that, well, I still want a vote of confidence, because assuming that these people now are disqualified, I still want to test the legitimacy of the government after excluding these persons. Can he do that?
If the arithmetic is so stacked, Malas, he can, but nothing more than that.
Right.
The arithmetic is so stacked, he can.
Because the consequence is that those people have to be excluded from the House.
I agree.
The number comes down, and then he can say, well, I want...
Correct. So therefore, the arithmetic...
minus these people who are disqualified to establish that
absolutely. No dispute on that proposition. But that the arithmetic will decide.
That the arithmetic will decide.
Here, that question doesn't arise. Yeah, we know he's made chief minister. You think by now the judges don't know he's been made chief minister? I don't understand. Well, your lordship is right, but then the arithmetic will decide. There is no discretion there. He'll call the chief minister. He says, these people are excluded. This is the arithmetic. This is what the numbers are. Prove your majority.
No, but then look at it this way for a moment. I mean, we are not at all on the facts here, but just to test a constitutional position, which is that, say or we can, just for the sake of clarity, the Shivsena has 56.
Yes, ma'am.
Or had 56 when the government was formed.
55,
right?
I thought, Mullah.
Oh, sorry, 55.
55.
55. Now, disqualification notices were issued to 22 plus 16, 38.
That's right.
So, for a moment, for the argument, we proceed with your hypothesis that this is a split and therefore they are disqualified. Right? So, then the Shivsena is left with 17.
Yes.
If these people are to be disqualified.
Yes.
So, it comes down to then 17 plus NCP has how many? 44 or how much?
54.
53.
53 plus 17, 70.
Yeah, I just see.
And Congress is 44, right?
Yes, 44. BJP is 106. Even then, it'll be fine.
Right. So, in such a situation, would the governor be justified in saying that, look, assuming that these people have incurred a disqualification, I still call for a trust vote, because the impact of these 39, at that stage, he is not deciding the disqualification. At that stage, the governor says, well, according to me, as a constitutional head, it appears that these people they have split. I'm not deciding that they have split because that's the discretion of the speaker. Can the governor now not say in a given case that, look, these facts now stare at me. I postulate that these people have incurred a disqualification. I don't treat these as members of the House at all. But therefore, because these people stand excluded, and the strength of the ruling of the government then falls down to the extent of the extent of the split, I want a trust vote.
Well, let me analyze that in two ways. Number one, you can't then administer an oath of office to one of those who is disqualified.
Yeah, you're right. Absolutely correct. Your line of thinking and line of argument on this is
okay. Now let's forget that.
That we'll keep aside.
Now, the power of the somebody should tell the governor that constitutionally what happens, from my little experience, the numbers, if stacked against the government, will go to the governor and say that the leader of the house has lost the confidence of the house.
Right.
Then he will analyze that and call. But governor will not do this. That's not his job. There's a sitting chief minister. It's an elected government.
You're right. At that stage, the governor is not really calling upon someone else to form government. But what he can certainly do is that, well, according to me, you have a ruling party with, say, which is supported in a coalition with, say, 60 members. Out of the 60, 40, which is a split. The governor says that, well, this is a split, and this is a split which is not recognized now by the 10th schedule. The speaker is going to take his own time to decide on the disqualification. But as the constitutional head of state, I do believe that with these 40, having, contrary to the constitution, moved away, at least as a head of the state, I require a trust vote on the floor of the Legislative Assembly. That I don't believe the governor would be wrong in calling for a trust vote.
I will say it is wrong, then I'll constitutionally provide an answer.
Why would that
be? The moment a governor does that, take Maharashtra, there are any number of parties apart from Shivsena, apart from NCP, apart from Congress, there are so many small parties. Now, those small parties at the moment supporting whoever is in power. The moment the governor does that, the buying and selling will start. In fact, the governor will be inviting, by his unilateral act of saying, prove your majority. There's no question of proving majority. He is the chief minister. Somebody else has to tell the governor that there is no majority. These are the signatures. These are the people who are with us. He doesn't have majority. If you allow that as a constitutional principle, Manoj, it will be disastrous for democracy.
No, but the very fact that a disqualification notice has been issued initially to 16 and 22, this is not a case where the governor is sort of, finding facts, in the political spectrum. The governor is informed, the governor knows that, well, disqualification notices have been issued to 16 plus 22 or a group of persons.
Yes.
Which disqualification, the wrath of disqualification, the moment it attaches to a very sizable portion of the MLAs who are part of the ruling coalition, can the governor be said to be not justified in saying that, well, I'm not deciding the disqualification, but now please establish that you have a majority in the House, and I'll decide whether your majority depends on these 39 or your majority is safe irrespective of these 39.
Even otherwise, on the arithmetic, the numbers are in favor of at that time, in favor of
because, Mr. Sibal, you are also right.
Independence of
Mr. Sibal, for the present purpose, because we still have to hear them on that aspect.
Yeah.
So, as a hypothesis, we proceed on the basis that you are right, that these 39, they had really split. That too, a split is not recognized by the 10th schedule. Therefore, they necessarily have to go out.
Right.
Asking Mr. Eknath Shinde to form the government, that's a separate issue. We'll keep that aside for a moment. We'll have to hear them on that. But as an abstract constitutional principle for the governor, what else does he do?
Let's analyze the numbers now.
Does he say that
he still has the numbers? He still has the numbers. They are only 106. There are independents, there are other parties.
No, that point is, Sybil, that is again, because, can we say that then the governor is, you see, a lot of times what happens is the governor may have done something which is absolutely within his power, something which may run afoul of constitutional principle. But we have to we have to separate the grain from the chaff. Per se, when there is a disqualification notice moved to the speaker, in respect of a sizable group of MLAs belonging to the ruling party, how can we say that the governor is not justified in going to the government and say, come on now, prove your...
When does a governor, we'll have to go into that question, then when does a governor call for a floor test? Then we'll have to go into that question. Has ever a governor called for a floor test on his own when there is a government in power? Never. Never in the constitutional history of India. Never. And the reason is simple. There is an elected government. He has proved his confidence on the floor of the House. There may be disqualification.
You see, because the defection has two consequences. At one level, the defection results in persons who have defected by virtue of a split, ceasing to be members of the House.
Yeah.
But that very defection, which operates to exclude them from the membership of the House, also affects the legitimacy of the government, legitimacy in the sense, the strength of the government on the floor of the House. So, therefore, the very same act, which is unlawful, of a group of persons forming a split and going out of the party fold, they incur the wrath of disqualification.
That stage would have arisen if the disqualification petitions had been decided. Let's assume, Malaz, that your Lordship's example is right. But that stage will arise if the disqualification petitions are decided and they are out of the House.
No, but for that purpose, can the governor not say, well, I assume that they will be disqualified, but therefore I need a show of strength on the floor of the House.
But the governor has to wait on the constitutional process, the outcome of the constitutional process. Governor cannot say, I'll assume this or I'll assume that. I'm sorry. This is a proposition of constitutional law, with the greatest respect, that will ultimately encourage the kind of things that are happening today and we see all around. Please. Toppling of the government should be the priority as far as the governor is concerned.
Mr. Sibal, you are saying that constitutionally it's impermissible for the governor to take cognizance of any of those events which are all over.
Correct.
Nevertheless, he has no power to take cognizance of either the 10th schedule notices or even the earlier notices with respect to the speaker.
Correct.
Or even those representations of violation of the whip and all that has happened in the papers
Yes,
all
yes,
over,
yes, yes.
he cannot by himself take cognizance of anything like that at
That's
all
correct.
and ask the legislator or the chief minister to prove his strength in the floor of the house.
Correct. Because they are part of the Shiv Sena. They themselves say,
We are not on Shivsena. We are on the power of the governor.
that's right, even then,
You're on
even
power.
then. When an elected government is running the constitutional principle, I humbly submit is the following. If the numbers are stacked against the elected government for whatever reason, they can go to the governor and say, these are our numbers, these are how they are stacked. Governor verifies that issue, verifies the signatures. Normally, that's a practice that used to happen, but governors now say we don't want to enter into the political thicket. But be that as it may, that may be a possibility then for the governor to say, look, I feel that you have lost majority because these people have come to us. But governor on his own can't do that. This is not no power of the governor to help in toppling an elected government. Whereas you assume governors will act constitutionally, but how many times have you struck down actions of the governor who have acted unconstitutionally? And once that happens, then everybody else will get into the act. All those independents and all those people belonging to small parties. I don't want to say anything more. So, please don't lay down a constitutional principle that will create havoc